Today I'll speak when your visa application is refused or asylum claim refused, you don't have given appeal right. That means you can't appeal against the refusal. Also, for example, you apply for visit visa, but home office refuse the visit visa and you don't have any appeal right. Or you claim a human rights application inside the UK FLRFP and your application been refused, you are given appeal right, but from outside the UK. That means you need to leave the UK and then you can appeal. How you can challenge that decision, that refusal letter? Now, following the Immigration Act 2014, all the appeal rights has been removed, unfortunately, except human rights application, humanitarian protection, or asylum case. Then, even if you claim human rights application, or if you claim asylum or human rights application, the Home Secretary can certify under the Section 94 that your case is not, it doesn't have good merit, so that he can certify, and then you can only option you can go back to your home country and you can appeal. So in that situation, basically, it is not helpful that you can appeal from your government. So the point is how you can challenge it. So that's what I'm going to discuss in this short video. So what you need to do if your application is refused without any appeal right, or out-country right of appeal, you can challenge it, the Home Office this refusal decision by way of judicial review. So what you need to do, the first things you need to do, within 3 months of the decision, you need to go to the you can go to the court to apply for a judicial review. However, the first step is you need to do is issue a pre-action protocol letter. What is pre-action protocol letter? Now, pre-action protocol letter, there is a form which is pre-action. You can download it online from Google. Pre-action protocol form for Home Office. If you Google it, you'll find it. So that form you need to. This is basically a letter to the Home Office that you either change the decision, give me the right of appeal, or change the decision, accept my application. Otherwise, I'll go to the High Court, or which is the upper tribunal, Immigration Upper Tribunal. Then I apply for permission for judicial review. Now, this pre-action letter, you should write it professionally, referring the grounds of judicial review, grounds of refusal, why you think the Home Office is unreasonable, or Home Office refusal is wrong. So there are 5 grounds which is you need to rely on, that is unlawful decision or irrational or unreasonableness. So these are the grounds should be explained how the Home Office failed on the reasonableness, why the Home Office decision is not according to law, why the Home Office decision is irrational. You need to explain it, and then you need to give refer some law, some decision of the Supreme Court for human rights case decision, or the immigration rules, immigration law. So these are, you need to refer the law and the fact and establish the fact that this is unreasonable. You don't need to establish all the ground. Even if you just establish that the decision is unreasonable, that is sufficient. But what you need to do, you need to professionally draft the pre-action protocol letter, and if you have a content, if there is a trigger good grounds, then what the Home Office will do, Home Office will invite you to reconsider the decision, and then Home Office will make a decision again. And again, if you give if they change the decision, of course you get visa. If Home Office decide, okay, you on out-country right of appeal, will make it in-country and you can go to appeal. So then you can go to the tribunal or appeal against the refusal. So it depends what the nature of the refusal and whether it's out-country right of appeal or not. Now, in case if the Home Office failed to respond of your pre-action protocol letter, or if the Home Office against they didn't, say for example, they hasn't changed, the Home Office has not changed their position of the refusal letter, then the next step, you need to go to the court, which is you need to fill the form for permission to judicial review to challenge the Home Office decision. Now, first, what will happen once you submit the judicial review application to the upper tribunal, the court will make a decision based on the paper. So again, if you just fill up a form, it will not help to go your case. What you need to do, you need to fill up the form properly and you need to give the grounds, law, everything, facts, so that you can establish that the Home Office decision was unreasonable. And then if the court, again, based on paper, Home Office, the court will make a decision. If the court grants you permission, then your matter will proceed for hearing. When permission is granted, so for example, so it proceed for the substantial hearing. And after the substantial hearing, before the substantial hearing, you need to provide the trial bond and you need to instruct a counsel to attend the hearing to represent you. The counsel will more likely draft a skeleton argument as well, and then the outcome. Now, in case if the upper tribunal decide to refuse your permission for judicial review based on the paper, then what you can do, you can make an application to reconsider the decision by the upper tribunal on a hearing, face-to-face hearing. Then it will be a hearing for whether that matter permission to be granted or not. And then if the court grant, again, it will proceed to a substantial hearing. If in case the court not grant, you can do appeal against the refusal to the court. So this is what the way you can challenge the Home Office decision in case you can't appeal against the refusal, or there is an appeal, but the appeal is out country right of appeal. That means you need to leave the UK and you can appeal. So pre-action protocol letter, and then go to court for permission for judicial review, and then it will be a substantial hearing if it is granted. If the court refuses, then you can appeal against the refusal as well. So I hope that information will give you, but what I would like to suggest you, if you are in a position like this, speak to a lawyer, because you need to draft a pre-action protocol letter, put the application for permission for judicial review professionally with the law, with referring the law and the decision of the Supreme Court or High Court or European Court of Justice, because this will help your case. And of course, you need to make the application within 3 months from the day you receive the court, you receive the Home Office letter. Thank you very much, all of you today. If you need any assistance, you can contact with us. My name is Suhail Ahmed. I'm the Principal Solicitor of SW Solicitor. We have office in London, Milton Keynes. However, we provide services remotely via Zoom meeting in the UK. So please feel free to contact us. Our contact details appear on the bottom of the screen. Also, you can Google SWF Solicitor.